Welcome to my channel, All for Health with Jane. Family, we are still having Brigadier Gininda on the witness stand, Mr. Ramusipili being the one who is taking him through cross-examination. Family, Mr. Ramusipili wanted to use photographs from docket 375. These photographs, which are the evidence of the investigation in that docket. Judge Ratha says, Docket 375 is not yet a case, but still an investigation. He says it will only become a case once there is an accused person who is charged in this case, and this person has pleaded guilty or not guilty in this case. Until then, it is just an investigation. In the opening of the court this morning, Advocate Baloyi objects to Mr. Ramusipili for the using of these photos. He says since they were not admissible in this court. He refers him to the previous study cases, but in closing, he agrees that Mr. Ramusipili can continue to use them. Judge Ratha gives all the other defense counsels to comment on how they feel about Baloyi's objection. All of them are for the opinion that all evidence available, including those of witnesses that were not yet called by the state, can be used, and the court will have the right or will exercise his right to strike them off the roll if the witness owning that statement is not called at the end of this case. Judge Ratha rules that the defense can use any evidence or documents, anything they feel that it will help them to prove their case against the state. So Mr. Ramusipili is being allowed to use those photos, even though he refused, saying he's no longer going to use them. Family, let's listen as Judge Ratha is giving out this ruling.
Yeah, as a general proposition, this court is obliged. I've listened to the defense and even the prosecution. The government of this debate is the fact that Mr. Ramusipili wanted to utilize photographs which apparently are the result of an investigation by the state in another case. And I think Mr. Baloyi initially objected that, but after some time relented to say, if Mr. Ramusipili wants to use that evidence, which is documentary evidence, he may deal with it as he wants. Am I quoting him correctly? That's correct. Right. Now, as we all know, the Constitution is the premier law in our country. What Mr. Baloyi stated about hearsay evidence is correct, no problem. And also what Mr. Mnisi states about Section 3 of Act 45 of 1988, the Evidence Act, which came into being 1961. I'm sure all of us were born. It's correct. But there is a rider here. I asked, how was this evidence acquired by Mr. Ramusipili? And Ramusipili said it was apparently discovered by the state before this matter was nullified. Is that not so?
No, it was during this matter, the current matter, not before Justice Maumela. It was in this trial.
Oh, I see.
Yes.
Is that so, Mr.?
Well, and I don't want to cast aspersions on anyone. The main disclosure regarding 375 was done during the trial before Judge Maumela.
Yes, I
don't
think I
remember
listened.
disclosing anything
That's it.
pertaining to the and as I say, my lord, we
No, fine. I hear you.
memory can sometimes leave us in the lurch.
Yes,
but
I listened to say this was discovered during.
yes, but
I even said my predecessors.
yes, that is my recollection.
Yeah, quite. But it was not formally discovered at the beginning of this trial on the 17th of July, 2023.
No, 375.
Yeah, 375. I'm talking about 375.
Yes, was discovered during the proceedings that were aborted before Judge Maumela.
Yes, that's how I understood it. You don't agree, Mr.
No, I don't agree, my lord.
You were all in court. I wasn't here.
My lord, how can that be?
I was sweeping the floors when you were sitting with my brother Maumela. I wasn't there.
But my lord,
And you can agree
yes.
on this. You were there during Maumela's time. You were there, or you are here during my time.
But the essence of my submission was that the question emanated from your lordship, not Justice Maumela.
Okay. Otherwise, we'll waste the whole time. Yeah, okay, let me just settle it. In terms of our law, the Constitution, about Section 35, 1C of the criminal process, of the Constitution, states that an accused person has the right to defend himself and to challenge the state's case also. Consequently, accused before court here, they have the right to challenge any piece of evidence. Like, for instance, because it has been discovered, this court doesn't have to inquire as to how it was discovered, because it appears that in any event, Mr. Ramasipili wanted to utilize this evidence of photographs or an album. And I don't want this case, wherever it goes, they say this judge never dealt with this exigency. So I'm dealing with it now. When you decide not to use it, it mustn't be said that I refused you the opportunity to use it. Okay? Because my finding, as I say, is that your client has the right to defend himself. And then in section 151(2)(a), at common law also, there has always been a right vested in an accused to call witnesses on his or her behalf. And that the Constitution recognizes this right in section 35, and also the Constitution now guarantees every accused person, as part of the right to a fair trial, to the right to adduce and challenge evidence. And this principle was reiterated in the case of S versus Duma. It's an unreported KZP case number AR 141/14. Where it was reported that it is an irregularity if a judge or a court denies an appellant or an accused person an opportunity to call a witness in defense of so fundamental a right that if that happens, it vitiates the proceedings in the sense that he has been deprived of a fair trial right. And this applies to all the evidence, documentary or even evidence relating to videos, photographs, and verbal recordings all evidence. And this was also repeated in the case of Ugwebu versus the National Director of Public Prosecutions, case number 86184/201, which judgment was delivered by my late brother, Classens, on the 28th of May, 2019. And at page 22, he says the court recognizes the right, and that this right is underpinned by a right to a fair trial, and entails that all available evidence, including evidence that would assist an accused in his or her defense, should be made available. All, irrespective of how that evidence was acquired or discovered. In S versus Maluleke, unreported case number CA and R 34/2013, which was finalized on the 1st of November 2013. The court at paragraph 60 confirmed that where the defense fails to call a witness whom he or she could have been called, it is open to the defense to request the state to make that witness available. And actually, to put it in its proper context, the state is obliged, if it doesn't utilize any witness or any document which pertains to a case in which the right to adduce evidence or the right to defend the state's case, that is by the litigant, the state is obliged to make that evidence available, whether it be, as I say, documentary, photographic, or through video material. So it's a legal question also that if the state is not in a position to call any witness, it is incumbent on the defense to do so if it so desires, in order to actualize the right to a fair trial and to adduce and defend evidence in terms of section 35(1)(c). This case is peculiar in the sense that this court finds that this evidence, which is apparently wanted to be used by Mr. Ramosepili, which pertains to documentary evidence of photographs which were allegedly acquired or taken in another case, it doesn't stop Mr. Ramosepili or any accused person to utilize that evidence, because the right to section 35(1)(c), in my view, it's more decisive than the right to the privilege which is supposed to be extended to any evidential material which is in the possession of the state. Because we must bear in mind that this evidence, we keep saying it's a case. It's not yet a case. 735, it's not a case. It's still an investigation. A case only commences when there's litis contestatio, meaning that it only commences after the state has placed or put a charge to an accused person and that accused person pleads. Only then does that evidence become evidence in the accepted way. Otherwise, still an investigation. So Mr. Ramosepili actually wants to use photographs which are pertaining to an investigation in another case. But I'm saying the right of his client to section 35(5) 1C supersedes even the privilege which the state could claim or wants to claim. Okay. So if you want to use that evidence, you may do so.
As the court proceeds.
Family, let's meet in the comment section. Thank you so much. Thank you for watching this video to the end. Please like it before you leave. Subscribe for my channel if you haven't done so yet. Family, I love you very much. Thank you. Bye.